All right, let's talk litigation holds. They're basically ESI preservation mandates, okay? And litigation holds typically take place at the commencement of litigation at some time. How many of you are responsible for propagating holds? Okay, so you know how time-consuming this can be. You know, and if you do it well, you'll be fine. If you don't do it well, a court will call you on it. It is an aspect of information governance. It's a critical and key component for preservation of evidence. It requires proper design, deployment, and enforcement. You should have your lawyers involved in it, and they should be doing more than just saying, well, if you think it's okay, that's fine, because the lawyers have to really look at this. First, they have to learn what it means, and then they have to reflect back to you and tell you how that, whether in their estimation this is going to cut it or not. So well-designed, they can provide robust defensibility of good faith management of destruction of electronic information. It really is critical. This is your get out of jail free card, and this is what you should be using. But let's go through a walkthrough. I like pictorial walkthroughs. So this is information governance. Real world, paper, computer. I use this. These are cheap pictures because they're free. This is old. These are old litigation hold targets. I won't tell you how old this one is, but it tells the picture quite well. These are new litigation hold targets. Litigation holds in ESI. They include storage media identified as repositories of potentially relevant electronically stored information. That sounds great, doesn't it? So, what do I mean? That's where storage lives. 32 gigabytes, right? Think about your clients. How much of your client's IP, how many of your proprietary secrets, how much customer information can be fit on this little flash drive? Lots. We're involved in lots of litigation where we see data walk. Okay? This is 64 gig. This is an iPod, right? iPod. Another place. I'm just listening to my music. But, you know, you can use this for storage, phone, storage, iPad, storage, management, nightmare, right? Bring your own device. That's like bring your own gun. You know, play Russian roulette with a fully loaded gun. So this is where storage lives. But that's not enough for the bad news. Okay? What do we do about the cloud? How do we preserve in the cloud? We don't even have information security standards in the cloud yet. Okay? We don't, right? How many security guys, you agree? I mean, I know the vendors are really like saying, oh, you got this, you can preserve and whatever. I haven't seen it yet. Okay, until you have security in the cloud, how are you going to have retention in the cloud? How do you know that your vendor is going to comply with your legal obligations if they're in Vietnam? How do you know that they're even going to outsource to Vietnam or cloud source to Vietnam, which may have no protection against your information? Your HIPAA-covered entity, your business associate, these are things you're going to have to know. If you're an attorney, it's even worse because you have an ethical obligation to preserve your client's confidences. And if it turns out that an attorney uses cloud information or uses a cloud sourcer, what happens then? Right? And I know it depends whether or not you're using application storage or platform for your cloud. But whatever you do, you have to look at your terms of service. You have to see how you are going to be protected for cloud information. So, litigation hold triggers, federal common law, Zubilake and progeny, federal law. I mean, you can have, litigation hold triggers don't have to be letters only. They can be events. Or they can be laws or regulations or contracts. Sarbanes-Oxley, HIPAA high-tech, breach notification statute compliance. As soon as you know you may be liable in the future for a certain type of litigation, it doesn't have to be any litigation in the world. It's not construed that broadly. That's something you have to think about. So let's talk about litigation holds, and lawyers talk about reasonable. You'll hear judges talk about reasonable all the time. It is the most amorphous term you can imagine, and reasonable is a determination that's only made after the fact. So you'll never know what reasonable is until a judge rules for you or against you, right? Based upon either decisional authority or in a precedent-setting case where you don't want to be the test for that case. So the first reasonable is reasonably anticipated litigation. Prior to litigation, when you're represented by counsel, maybe you're not even represented by counsel. Maybe you still have an obligation to preserve. You know, you have compliance issues there. Scope and trigger, we talked about that yesterday. Judge Shinlin talked about that yesterday. Duration of anticipation issues, how much, how long, before, after litigation. We're talking information governance. People talk about disposal. or destruction of evidence. I don't understand that, because unless you talk to me about disposition, I don't know what's done with information. Disposition gives some sort of finality to what you do to electronically stored information. Because disposition can be an archiving, it can be actual shredding of a hard drive, it can be wiping a drive, it can be wiping of a drive or wiping of information after litigation. So disposition is really the word that I think is most properly used.